Good evening, everyone. Welcome to the Developmental Review Board meeting for the Town of Essex. Today is Thursday, June 5th, and I'm calling this meeting to order. As always, we'll start the day off with quick introductions of staff and or board members that are here today. Let's start with the staff today.
Sharon Kelly, Zoning Administrator.
Kent Johnson, Town Planner.
Nick Martin, Board Member.
Stephanie Bixby, Board Member.
Ian Carroll, Chair.
Trevor Williams, Board Member.
Dustin Brusso, Board Member.
Hubie Norton, Board Member.
And absent this evening is Sharon Zakowski, Board Member. First item we have on our agenda is, do we have any additions or changes to our agenda this evening?
None by me.
None?
None.
Anyone on the board have any changes? Okay. I would take a motion in that case to approve the agenda.
So moved.
Moved by Dusty,
I'll second.
seconded by Nick. Do we have any further discussion about the agenda? Hearing none. All those in favor say aye. Aye. Opposed? Motion carries 6-0. Next item that we have up this evening is for public to be heard. This is the section of the evening where we talk about, you have the opportunity to discuss anything that is not on this evening's agenda. I will just be a quick note that we're going to limit a majority of those discussions to 15 minutes total. In particular, if we get sidetracked on one particular conversation, we don't have a heavy agenda this evening, but we want to try to keep the schedule moving along. If there's anyone that's has anything that they want to say, both online as well as in person, we are hopefully taking comments that are new topics to us. If you've already spoken at other meetings about specific items, we count that as already being on the record, and we'd appreciate new information if you want to speak to something that's not on the agenda this evening. That said, if anyone's in the room that has anything they'd like to share this evening, can I have you raise your hands? And those of you online, if you wish to share this evening, if you would use the hand emoji and raise that as well. And I will ask all of you if you affirm that the evidence you're going to give in this cause under consideration shall be the whole truth, nothing but the truth, and under the pains and perjury of law. You do. Thank you. I didn't see anybody online, so if we do have anybody online commenting, oh, I'm sorry, Cheryl, you did swear in. Thank you. Okay, that said, is there anyone here in the room that has anything that they'd like to add? Certainly, sir. Come right on up. And when you come up, if you would make sure that you identify your full name and as well as address for the record.
Hello. Can you hear me?
Yes.
Cool. Dwayne Millar Barlow, and I'm at 12 Rosewood Trail, Essex resident.
Mm-hmm.
So, yeah, the reason that I'm here is because, and you may have already seen my letter, and I have actual new information about this, but it's about comments that were made on May 29th, and specifically Dusty Brusso's comments, and I want to clarify that by talking about Dusty's comments, this is not a personal attack. I have a lot of respect for everyone here.
Which application are we referring to?
For the May 29th meeting, and the comments were about the role that the town plan plays in site review, and so the new information that I had, because I've been doing some research about this, and I bring this with humility. You folks know a lot more about these regulations in general than I do, but I did look into the claim that that the DRB was limited to looking at just the zoning regulations and not the town plan. Dusty was replying to, frankly, a lot of people who were quoting from the town plan at that time. And in fact, our zoning regulations 5.6 in two different places list specifically that during site review, that the DRB, when they're considering whether to approve a development, that there are 4 criteria. They're listed in numbered order, and the first criteria is that it should conform to the duly adopted town plan. The second criteria is that it should follow the regulations that are in the documents, And then the third is protect the health and welfare of the. I shouldn't claim to quote that directly, but there are two more after that. But in fact, the town plan is called out specifically. I raised this at the select board meeting, and the select board chair mentioned that folks are taking this seriously and that they're looking into potentially having a correction about this. The new information I have is I've been doing a lot of research about this, and I have a report that I'd love to share with you about the municipal plan and its statutory role, not just what its statutory role in site review specifically. And I learned a lot reading this. I learned, frankly, this is probably a lot that you already know, but the specific passages are, when it's talking about translating what Dusty was referring to, this largely corroborates exactly what Dusty was saying, that the municipal plan or the town plan will be translated into actual regulations. But it says some municipalities explicitly incorporate direct plan consistency checks into their review process. For instance, the Development Review Board checklist from Middlebury includes questions such as, is the project compatible with objectives of the town plan? And does the project comply with and actively further the town plan as criteria for review? And then later it says, as noted above, some municipal bylaws may go further and explicitly require the DRB, to consider a project's consistency with the municipal plan as a specific criterion during site plan or conditional use review. In such cases, the plan's influence is direct. And it's pretty clear that we are one of those municipalities that explicitly lists the town plan as a criterion, and it's in section 5.6. So there is a lot of urgency to getting this sorted out, as knowing what the legal standard is that the DRB is upholding is obviously very important. Since tonight isn't a site plan review, it's not as urgent as right now sorting it out, but it is quite urgent as we have, the next meeting I think would be further more around the site review, and I'd love to share this document with folks, and I can also send it as a PDF so it can be in a future agenda packet.
Okay,
Thank you.
provide one additional comment for this.
Certainly.
So I would recommend that as you're using that reference, that you also pull up any of the applications and look at the language that the staff has written into those into the application forms that we look at.
Yeah.
There is a section that says, is this in conformance with the town plan? So there is an interpretation of that at that point. So I think the point that you're trying to make is the town plan incorporated? It is incorporated, and the staff acknowledges that in almost every report that we look at, and we work from the staff report. So
the section 5.6 is about the role of the DRB, and and it's the role of the DRB to also ensure you don't just blindly accept whether staff says.
Yeah, understood.
Right.
Understood. But we work from the report that they give us.
Right.
And-
But
and
it's not the role of the staff to tell you whether it conforms to the town plan. It's simply not the role of staff to
Understood.
do that.
My point being simply is that it is included in the review.
Yeah. Sure.
Thank you for bringing that to our attention.
Fair.
Thank you.
Always looking for members of the DRB. Sounds like you're well informed, so next time openings come up, step up. Really, I'm serious. It's a challenge to get people to serve on these boards.
I'm flattered by that.
I'm not seeing any hands online at the moment, so do we have anybody else in the room that has anything that they would like to add this evening? Yes, in the back, ma'am.
Hold on 1 second. I might not-
Okay.
Okay. No, you can fill me in, and then I'll tell you if I'm gonna fill you in. It's Mary Post. I live on 1 Cindy Lane in Essex.
Okay, thank you.
And I didn't get to see the agenda, so tell me if it's inappropriate and I will sit down. But I wanted to make a comment about what's on, I believe it's about the end of Tanglewood.
Okay,
adding
that is an item that is on tonight's agenda.
Sorry.
So yeah, that's an agenda item this evening.
Okay, I just wanted to make a comment about this, about the history
Sure.
of
I
Birchwood.
don't mean to stop you here, but it is an agenda item, and there is an opportunity to speak during.
Oh, it is an agenda item.
It isn't it? Yes.
Okay, if
The
I'm
the
okay.
item number 6, or excuse me, number 5 is part of it.
Okay,
Is
I
part
misunderstood
of the
you.
public
Okay,
hearing.
I'll wait.
Yep. Yep. Thank you.
Thank you.
Anyone else? And anyone online? Okay. That said, I think we will move on now to the next agenda item, which is the public hearing. This is a hearing that's continued from May 1st. This is John and Meredith McClellan's proposal for a 2-lot simple parcel subdivision and waiver at 56 Tanglewood Drive, located in the medium density residential district, or an R2 district. Lot 1 will be 3.21 acres and contain the existing single family home. Lot 2 will be a 1 acre lot for future residential development. I just want to note that this application was originally set as a consent agenda item on May 1st meeting and was continued when we realized we pulled it out of being consent agenda and now as an agenda item this evening. Remind everybody that the format of the DRB meeting is very much like a courtroom experience. There are rules and procedures on how we hear an application, what we base our decisions upon. DRB will be finishing the public comment portion of this meeting, which was not concluded on May 1st, and we would like members of the public who have not already provided feedback have an opportunity to speak first. Okay, Kent, do you mind just doing a quick rundown on where we're at? Oh,
Thanks,
Sharon,
Janet.
go ahead.
That's okay, thanks.
Yep.
So this application was continued from the May 1st meeting due to technical difficulties and the need to include a waiver in the hearing notice. That's been corrected. We seem to be working fine with our mechanics here
This evening.
this evening. The owners of 56 Tanglewood Drive are proposing a simple parcel subdivision, including a waiver of subdivision regulation section 3.1D, which requires a second access for development over 50 dwelling units. Subdivision regulations required a second access for developments over 50 units effective September 1996. In 2012, the PC approved a 5-lot subdivision to include 2 residential lots on Rosewood Trail and 2 residential lots on Tanglewood Drive, with the remaining 44.7 acre lot conveyed to the town of Essex. This approval was appealed in 2012 to the Environmental Court over the lack of 2 separate connections into the development. The court upheld the PC decision. Regarding the staff report, line 168, change the date to read April 21st, 2025, sorry, and comments to read, there are no comments. So basically finding 12 and finding 13 weren't updated, so apologies for that. Line 170, change the date to read May 30th, 2025, and again, the fire chief comments, and his comments read, in an email dated his comments read, no objection. We only ask that each residence be clearly labeled with their 911 address for ease of locating them in an emergency. So that's been fixed in the staff report. In looking at the assessor's records, I counted 163 homes in the Birchwood development. A court decision as well as waivers have been granted to this development to reach this development number. Let's see. The applicants have agreed to a condition as follows. The applicants shall submit draft deeds for the proposed lot and amended deed for the existing lot for review and approval by the town attorney at the applicant's expense. Proposed deed language should include the following language. Each lot is approved for a single-family structure. No further subdivision or dwelling units, including accessory dwellings, shall occur on either parcel. This could be added if you wanted to, as the planning commission finds your usual blank one, or we can just add it in. And So I don't know that I have too much to say other than ask you if you have any questions from the staff report. I can give you the specifics if you feel we need them on the sizes of, well, I guess I will. The McClellans own a 4.21 acre parcel, and they're looking, oh yeah, did I not put it in there? The parcel will be divided into a 3.21 acre lot for lot 1 and a 1.0 acre lot, lot 2. And really, I guess I'll just answer any questions that you may have.
Okay, thank you. We're going to mix it up a little bit this evening. Trevor, do you have any questions?
No, I don't.
Okay. Nick?
Yes, one question that popped up. Could staff please answer on this development where there are 163 homes accessible to only one outlet? Or is there any other property that is not residential?
In that development, in the Birchwood
Yes.
development, no, they're all residential units.
Okay. All single-family home residential?
Yes.
Okay.
I do have, I did calculate the breakdown of each road and how many single-family homes are on them. I don't know that you need them other than to know there's 163.
That's okay. That is my only question right now, Mr. Chairman.
Thank you. Hubie?
No, I have no questions at this point.
Thank you. Stephanie?
No questions.
Dusty?
I guess it's right now. I have a sort of. That's fine. I'm working up to it. I'm struggling a little bit with the format that we're following, because we're talking about a waiver, and the waiver in the staff report says a waiver was requested, but there's no language in the staff report denoting the waiver that was requested. Normally, you reference the report references an Exhibit A, and that's the first time we've ever had, in my recollection, a waiver request that's external to the staff report. In practice, the staff report has included all of the requests and reasons for a waiver, so that it's contained within the report. And I'm not seeing that, and I'd like I'm not judging on the waiver at this stage. This is not.
So I'm sorry, you'd like.
External documents get lost. And there's the Public Works references support for a waiver. Why? They've got some reasons, but the applicant submitted a request for a waiver, but that's not included in the staff report itself. And that's my question, really. That's a format question more than anything else. So we normally reference we don't usually reference external documents with primary content. We usually embed it in the staff report.
So I guess what I'm hearing is that we don't have a specific comment, a statement from the applicant stating they're requesting this waiver, but we do have comments from departments.
Departments don't request the waivers.
No, but in response.
And the applicant has to provide, if they're requesting a waiver, they have to provide the reasons for the waiver, not the departments. So, and then we, in general, the departments and or the boards agree or disagree with the request from the applicants. And I'm not seeing the request from the applicant in the staff report. That's where I'm trying to get to.
Okay. Maybe we can amend it. I think it was pretty clear at the last meeting before audio troubles happened. You had had your statements state that it needed a waiver. So I mistakenly assumed that, okay, we have to come back to address the waiver. And technically, I might have an email. I'd have to wait for.
Well, we've got a document from the applicant stating it's your exhibit. It's the Exhibit A.
Right.
That has their language as to
Okay.
what they're requesting and why.
So it's because I didn't embed it.
That's
into
not
the
in.
staff
To me,
report.
that's not in the staff report. So that's not part of the request. And that's what I think is missing. Nope. That's why I'm saying this is a format issue for me, and I'm going to look to the rest of the board. I get nervous when a document, which is key to the format of the report, is not in. There's not content in the report and now we have to reference something else, so we're having to keep track of another piece of paper.
Okay, so I don't know how to answer that. I mean, it is a part of the staff report. So if this were to be appealed, that would go with the staff report, the attachments.
Okay, I mean, that's I guess for the commission to, whatever, it's a different approach.
Right.
It is not a process that has been followed at
Well,
any point in time.
we did it in earlier years, but, you know,
Must have been a lot earlier.
well, we've been here a long time, Dusty, so. Yeah.
Yeah.
The Harry Smith reign of community
I
development.
probably wasn't even out of school then.
So the question
And
question
Herb Murphy, yeah.
is
My question would be, I would be a lot more, my statement would be, I would be a lot more comfortable if we would pick up and embed the request from the applicant into the actual staff report and not as a reference addendum.
And are you looking just for the specific words request for the waiver, or and still
No, I'm
keep
taking the
attachment?
content, the core of what they sent. I would recommend that we input that in, and then we have a spot in the DRB finding area to say whether or not we agree with or disagree with the request for the waiver. Because I mean, whether or not Public Works says they support it, whether or not the fire department says they support it, is not a key factor. It's a key factor, but it's not the deciding factor, and it's not the voting factor for the approval of the application or the denial.
Yeah. I think that's,
But this is to the rest of the
okay.
commission to, board to
QB.
speak to.
I guess I'm confused, like Vinnie Barbarino. Okay, I'm looking at the staff report that says findings, and I go down to line 152, number 7. The applicant's engineer submitted a supplemental letter to the application dated May 2nd, 2025, addressing the waiver. See attached letter marked as Exhibit A. Exhibit A, May 2nd. Dear Ms. Kelly, on behalf of the applicants, blah, 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 please accept this letter as a formal request for a waiver. What more do we need?
Again, that's why I said that in my opinion, it was purely procedural, and it was the fact that it was an external document. And if the board is comfortable with that, so be it.
Well, it's listed as a finding, okay, by the staff.
I'm not arguing that. I'm saying that it's not in the report. It's not, the words are not in the primary report, and that's a different approach. If you were to pick this up and that finding A happened to have been separated from this report, you wouldn't have it.
Well, our usual procedures are we have findings. We usually accept the findings of the staff and add our own, maybe with some modifications. But I would expect that we would accept this finding, number 7, that the applicant's engineer submitted a letter that's saying they wanted a waiver. I don't know what the problem is. Anyway, okay, that's my comment. I don't see that there's a problem.
okay.
Fair.
Trevor.
Well, I mean, if you reference it as Appendix A to the staff finding,
It should be.
doesn't that mean that it's included? So,
Fair enough.
yeah, that would be my how I picture it.
And the fact that it's an Exhibit A, but not present in this packet, is that where you're struggling with? Dusty, is that a fair roundup of it?
I'm struggling with 10 years from now when this packet is picked up. It's not in the report itself. It's a supplemented document. It's an attached document. Should it be part of it? Yes, it should be, but it's not in the report itself. It's a separate item.
Okay.
And that's strictly it. The content, the request from the applicant, I thought looked good. I see references that they submitted it. I see references from the Public Works that they agree with it, et cetera, et cetera. But it's, to my,
The fact that it's not included
it's
here.
going to be harder to manage it down the road.
We can take care of that. We'll just include it as we'll include it as a part of the application.
That's really,
I don't see what the problem is, really.
well, that's fine. That's why there's enough people on here to decide whether or not it's an issue or not.
Nick?
No issue.
Stephanie?
No issue.
I understand where you're coming from, Dusty. I don't really have an issue with it either, as long as we make sure that it's included in the packet going forward. I'm not in this packet, obviously, but it's part of the record. Okay. Any further questions? Are you? Okay. Any
No,
further
it's not a
questions?
debate. It's
No.
just a.
Yeah. Any further questions for staff at this time? Okay. We'll give the applicants an opportunity to come up and speak. Evening, and if you would, just state your names.
My name is Jeff Kirschner. I'm from Hamlin Engineering, and this is John McClellan. I'm going to be brief. I think we've talked about this quite a bit. I think the application is pretty complete. I think the staff report says that it meets it. We've requested the waiver now. There's just a couple of items that I wanted to bring to your attention, and it had to do with the Public Works comments. They submitted some comments on the initial application, and then on April 22nd, I actually met with Aaron in person, and we talked about this project and went over what I had planned to do to address his comments. We revised the plans and provided the letter that's in, I think it's Exhibit B. And so that addressed, as far as I know, that addressed all of Aaron's comments. And he provided a follow-up email that said that same thing. And in reviewing the staff report, there's some comments, there are conditions that were Public Works comments. Many of them have been struck because they've already been addressed. There's just a couple of them that were not struck that I just wanted to bring to your attention, that they seem to be conditions, and in my mind anyways, they've already been addressed. Maybe a moot point, but since some are struck, I wanted to just bring it up. So number 5, talking about the driveway apron meeting the standards for drive aprons in the town specs. There's a note on the plans that says that. We actually revised the detail to make sure that it did, and I believe Aaron, that's encompassed in Aaron's acknowledgement that that 422 letter met his conditions. Number 7 talks about a clean out will be required for bends in the sewer service within the right-of-way. Those all bends in the right-of-way have been provided, and so in my mind that one should be struck as well. And I think there's one more, number 12. Backfill lifts within the right-of-way shall not exceed 6 inches. It was a standard detail that we had that I've changed to address that. So in my mind, that one also ought to be struck. And that was all that I had. While I'm here, I will answer any questions that you guys have for us. And I don't know if Mr. McClellan wants to say anything, but
Mr. McClellan, do you want to say anything?
No, just, I think we kind of met everything that we needed to meet to do this, right? I don't know if people thought that the intent was to have this be, like a multi-unit kind of thing. It was just a single-family dwelling, additional home lot at the end of our property.
And I think that that was addressed with the potential condition that we may place on that this evening.
And if I could speak to Jeff's striking 5, 7, and 12, I agree that they've been met. I didn't strike them only for the reason that when it comes time for the contractor to build the home, they see it still. So it's done. I didn't feel it was hurting it by keeping it there. It helps me with my CO to ask Public Works, okay, did you get this and this and this? And that would be the only reason. You can certainly strike it. I have my own notes, so when it comes time for a CO, if approved, I can refer to those. So I'll leave that.
The inclusion does not create any additional burden, correct?
No.
Because you already met.
It's already been done, so.
met.
So it's,
Yep.
whether it's there or not, it doesn't harm you guys in any way, shape, or form.
to your point, it's procedural in my mind, just because some have been struck, the others
Yep.
hadn't.
Right.
That's all.
Yeah.
I'm an engineer. I can't leave it out. And I don't know if you guys have any questions on the waiver or not. It sounds like it's pretty clear based on your comments, but I'm happy to answer any questions on that as well. That was filed on May 2nd.
Well, let's see if we have any questions from the board. Hubie.
Nothing at the moment.
Okay. Dusty? Nothing? Trevor?
None from me.
Nick?
Nothing.
Stephanie?
Nothing at the
Nothing.
moment.
Okay. I don't have any questions for you about this application. Why don't we take a motion to open the public hearing and see if
It's already open.
it's already open. You're right. That's right, because it's still continued. That's right. So now we'll entertain those that are in the public. Gentlemen, if you don't mind, we're going to use those seats for those that can come up. If we have people online or here in the room that would like an opportunity to speak, go ahead and raise your hand. Thank you very much. Come on up, have a seat, and let us know who you are and where you live.
Thank you, Mr. Chairman. My name is Betsy Dunn, and I live on 2 Cindy Lane in Essex.
Okay, thank you.
You're welcome. I'm here to urge you to deny the waiver for 56 Tanglewood Drive. Granting the waiver comprises public safety and contradicts our town plan and misuses the waiver process. First, on public safety. Our regulations require a second access for developments greater than 50 homes. Birchwood Manor has 163. One large pine tree could knock out the entire access. Waiving this requirement is not the minimum modification that the applicant claims. It is a significant safety risk that has grown with each only one more approval. Second, this waiver contradicts our town plan, which calls for a walking and biking paths to improve the safety, especially for children. We can't install this vital infrastructure because the width of our only access road is Tanglewood Drive, and it's being used for a poor substitute for required second access. Third, the waiver process is misused. Waivers are for rare exceptions with substantial justification, not just routine approvals. The applicant should provide substantial mitigation for a waiver and still comply with the essence of the regulation being waived. In 2011, an approval in our neighborhood required the developer to donate 44 acres of forest land to the Essex Park system. This applicant offers no such mitigation. Furthermore, the circumstances have significantly worsened since the past waivers were granted. Our neighborhood is served by a crumbling, asbestos-lined water lines that are already lack sufficient water pressure for existing homes and hydrants. The application's map shows that deep ravines surrounding our neighborhood that are collapsing from the excess stormwater, which Public Works has been working with and battling for years. Even adding one more home along these ravines could strain this failing infrastructure further. In the 2013 court decision that the applicant refers to, the judge was unaware of a future Act 47 would allow more density to a neighborhood that is already 4 times over the limit that triggers a second access. We are well past that point. The court decision required that no development occur on the donated parcel without re-examination of the need for an additional accessway. Finally, the applicant's claim that the fire department is 300 feet away is misleading. This simple parcel will be over a mile from the fire department, down a single road that serves the only way in and out of our community. The choke point at Glenwood Drive is 1,587 feet to the dead end, when the limit for a dead end is 900 feet. Another regulation that we didn't follow. Granting this waiver increases risks for 200 households, contradicts our town plan, and strains failing infrastructure. Rubber stamping this waiver, because it's just one more, could open the town to liability for knowingly allow an unsafe development. Please uphold our regulations and deny this waiver. Our neighborhood needs a second access before we need to have another home. Thank you.
Nicely said, nicely written. Okay. Yes, sir. Good evening.
Hi, I'm Bruce Post, 1 Cindy Lane. Dusty, we come full circle, don't we? When I just before I bought my house, which at that time nothing was behind us. I went to the then zoning administrator, Jerry Furkey, and I said, can anybody build back there? And he said, no, they're going to need a second access. And he said, but developers are creative. They might buy a house and build a second access that meets our requirements. But no, so I think for about 10 years we were there, and then all of a sudden we got an abutters letter that development was going in behind. I know the land was for sale, I think for about $300,000 by Richard Pope, who was one of the original developers. It was bought by Owen Jenkins, the late Owen Jenkins, who was an attorney here in the village, city now. And from what Mr. Pope's son told me, he told Pope that $300,000 was too much because, you know, one house would trigger a second access, and he paid for about $200,000, and then much more went in. It was a very difficult experience for us, having been through all that. And I participate in town affairs. I've been a selectman. I was state planning director for Governor Snelling. I know planning. It's nice to know, to have an expectation that rules, when they're made, are followed. And what concerns me most is waivers and waivers and waivers and waivers. I don't know if Essex has a motto, but it could be exceptions are the rule. And I have no malice toward people building a single-family home necessarily. But with the new legislation that's come out of the legislature, which in many ways diminishes public participation in zoning rules and planning rules, I'd like to see us stand up for what our rules are. I would be concerned particularly if that lot could be the site of I think it could be a fourplex because it's on city sewer and city water, and that's been encouraged by the state legislation. So I'm just saying, I'm concerned as part of a pattern that citizens participate, they make their input. It's not always accepted, but they like to see that there's some consistency in the rules. And if exceptions become the consistency, I think it leads to chagrin and a disillusioned electorate who don't want to participate in town affairs because they say, what's the use? So that was my experience. Also, as part of the court case, I was a pro se applicant. We settled in mediation. The court asked us to go to mediation. And, you know, if you ever want to fight a developer, it's even harder when the developer is an attorney and they can run the clock on you. And you only have limited resources to try to deal with it. So there was a settlement, which I think was reflected in that decision. Thank you. And I'll take any questions if you have any.
Thank you. I don't think we have any questions from the board, do we? Do we have it? Yes.
Yeah, I do.
Yep.
Bruce, do you know what's always it's been perplexing to me is that why didn't Owen split this lot up before?
Pardon me?
Why didn't Owen split this lot before and put a house here?
It might have been a pre-existing lot. I think a lot of those were pre-existing lots. The town had an incentive for a waiver because it owned two of the lots for back taxes, and it made money off those lots. The town also paid $60,000 for him to put the sewer he was putting in deeper so that there could be possible connections in the future. The developer wanted to put in a sewer so he'd have more houses back there than he would if he didn't have sewer connections. So I don't know why Owen didn't do it, but that may have been the dimensions of a pre-existing lot, and he just let it go at that.
No, it's curious to me that he didn't optimize the opportunity there.
Well, he did. I think, though, he did shrink the lot size of some of the lots because that's why he wanted to put the sewer in, to get more houses in than they were permitted under the pre-existing system. That's what I remember, Huey, and it's a while ago now.
Any other questions? None?
Thank you.
Thank you.
If I could just add.
Please.
To reinforce, all departments have no issues with this proposal. And again, the current landowners are agreeable to have deed language state that, I apologize, I might have read this earlier. I'll read it again. Each lot is approved for a single-family structure. No further subdivision or dwelling units, including accessory dwellings, shall occur on either parcel.
And that would be in the deed.
And that would be in the deed. It'll be a condition of your approval, and the deed would have to capture that.
So that would limit that.
Do we have the ability to, I mean, does that truly limit it when the state says you can have an accessory I mean, that sounds like we're
The
trying
Birch, this particular parcel, the bylaws don't allow for an accessory dwelling unit. Again, Owen was an attorney, so it was
What bylaws?
zoning regulations.
Okay.
So you're saying it's written in the deeds currently?
I didn't look at the deeds, but that is my understanding, is that
There couldn't be accessory units?
there could not be.
No mother-in-law apartments, per
Right.
se, or whatever?
Right.
May I ask?
No other, yeah, go ahead.
I'm sorry. May I ask? This is how mine works. My mind works. They sell the lot to someone who says, we're coming in and we want to put in a fourplex. It meets the standards. If it's an acre, it's on town sewer and water. And as long as one of those units, if I read state law correctly, is affordable, people can't even say it's out of character with the neighborhood. I mean, the state is really giving us a top-down housing law, which does minimize citizen participation to a great extent. So that's my concern, is you put a stipulation in a deed and a new developer comes in and says, well, really, we disagree with it, we're going to ask a waiver, and we want a fourplex in there, which will change seriously that part of the road, and it'd be 7/10 of a mile to get there from the entrance. So that's, I don't know if that's reassuring or not. Sharon, I don't know if it's binding or not.
So question, if I can. That same restriction that we're talking about, the accepting to put on the new lot 1, would that also go on the existing lot 1?
Both, so that right now, what's the address? Sorry, 56 Tanglewood, would have that statement in its deed as well as the newly created lot.
So 56 would not be able to, the
existing
new lot
lot
1
right
could
now,
not, the
right.
lot 1 could not be subdivided any further.
Two lots.
Lot 1 new
Right.
could
Well,
not
one
be.
is 1 acre, so, but again.
And I'm just looking that there's no, I'm looking more towards the potential of further subdividing the original lot, which is still 3
Right,
point X acres.
right. So they're agreeable to put on the deed, so whoever he has as a buyer will know that going in, because the deeds will be done and approved by the town attorney. So,
May I have another question in regards to that?
Certainly.
Does that apply only to that lot? Because there are other lots where you can put
it-
ADUs, and the state has really relaxed the requirements for ADUs and what a town can do to stop them. Part of the limitation on that in the Birchwood neighborhood would be most of the lots are on traditional septic system, and several have failed. It's at this end of the neighborhood that we have water and sewer. I think there are 16 units on water or sewer. Can I put in an ADU and
I have
without
not,
restriction?
I have not looked at the previous, I looked at the last 5-lot subdivision, which were the 2 on Tanglewood, 2 on Rosewood, and the remaining lands. 4-lot subdivision with the 5th lot in space. So for that development, I'm sorry, for just this parcel, it would only affect, but the bylaws that Owen created, and that would be a question for an attorney, says that no accessory dwelling units are permitted. How that can change, I don't know. It's a legal question.
And that's why I'm trying to think larger than this particular piece of land, given the tremendous complexity of the legislation that's come down out of Montpelier regarding ADUs and multifamily dwellings in traditionally single-family neighborhoods. And I wish I had the answers, and I don't think many select boards, DRBs, and planning commissions have it either. So that's
No, their goal
why
is
I'm
to
asking. And then
increase-
somebody else comes in and says, well, you just gave another waiver. How about this? And that's what I'm concerned about, is the multiplicity of waivers. And I don't want to take any more of your time, but thank you for listening and allowing me to query staff.
Thank you. I do see that we have a hand online. Gina Halpin Barrett, you're recognized. If you can lower your hand, turn on your camera, and go ahead and have your say. Did you take the oath, Gina, as well?
We did. It's her sister, Lorraine's alone.
Okay, I didn't see your hand originally. So are you hereby testifying with your own free act and will, and everything will be a truth to the best of your ability?
I do.
Thank you.
I just have a couple questions.
Okay, so that's Lorraine.
On the traffic, it connects to Sand Hill Road, right?
I believe that.
Yeah.
Yeah.
Yes.
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 Yes. Through the
Big
town's open
concerns that
space.
we're having with their traffic patterns are because we're really hemmed in on this part of Essex by 15 and 117 with only two north-south connectors, which are Sand Hill and the Cirque. And we're adding more traffic again to Sand Hill, which already struggles with traffic during school hours. I don't know if people, or maybe Aaron went down there during school time, but that traffic backs up and out, and we're adding more traffic to an already problematic area. And then the other question I have is, in terms of the outlet, it looked like in the report for the fire chief or the police, the public safety, am I reading it right that it says that there would be a non-public or not a roadworthy second access that would be for public safety only and pedestrian? Did I read that right?
What line are you referring to, Lorraine?
Oh, I don't have
so
it up
I
on
have at the
but it was
beginning-
where if you
at the
go
be-
down to where the our public safety weighed in, where the fire weighs in.
Right. So
And the part,
the staff report that went out had an error to it. It wasn't updated. So at the beginning of this hearing, I stated that the fire chief, so it should read in a memo dated May 30th, 2025, the fire chief said, sorry, I'm trying to read my writing now. No objections. We only ask that each residence be clearly labeled with their 911 address for ease of location in an emergency. And with finding 12 should read, in an email dated 4/21/2025, the police chief said no comments.
so we don't know, just no comment basically. And do you know why that changed for the fire from that first?
Well, because
what I'm reading?
I used an old staff report as a template, to be honest with you, and I didn't change that one.
Oh, so they didn't say that. That was
They said exactly,
Right.
yeah, exactly what I said, just read to you.
the amended
Yes.
stated is what they actually said. I also really struggle with the waivers that we give out like candy. It's problematic for me, and certainly I lose trust in my government and governance because waivers are supposed to be the exception and not the rule, and unfortunately it seems to be a habit for our decisions. So I would like to see this applicant also denied the waiver. And thank you for listening, and I appreciate your work.
And I just have a question myself about the connection to Sand Hill Road would be on foot, right? I mean, you come in off Sand Hill Road into the development, so there's only one access in. But yes, coming out, you're on Sand Hill Road.
Yes. There's a Sand Hill
Okay,
Road.
sorry,
entrance.
I thought she was asking, are there two currently? So
Now, there'd been discussion about potentially putting one in off from, I don't remember the first, is that the first one potentially into the pool? Into the pool area, because
Right.
that was a potential access, but that wasn't really doable either at the time.
Mr. Chairman, I take umbrance with the comment that we hand out waivers like candy. We're giving these consideration, and there's reasons for waivers, and maybe everybody doesn't agree to it, but to suggest that just applying for a waiver and it's automatically granted is Not true.
You're saying we're not willy-nilly?
We're not willy-nilly.
Okay, I appreciate that, thank you. Any further questions for staff or applicant? Anyone else in the room? Yes. Can you wait until you get to the microphone just so you recognize? Thank you.
I'm Carolyn Lewis. I live at 3 Cindy Lane. I did take the oath on Zoom last time. I am not sick. I'm trying to protect my own health, but
Fair enough.
I can talk better without this.
And were you here when we gave out the oath this evening?
Oh, no, and I got here late.
Okay, so then you raise your hand. Do you swear that the testimony you're about to give is the truth, so as to the best of your ability?
Yes, I do.
Thank you.
Yeah. So mostly I'm just here in support of denial of the waiver with apologies to my neighbors. Yeah, the access, thank you for the history, Betsy, and the access would be one of the main issues, which I don't see when it's going to end. One more house and one more house and one more house, and I think already it's just so compromised. I mean, there's a big hole in the middle of Tanglewood now, and if it falls apart anymore, you know, too bad for Cindy Lane and the end of Tanglewood. So anyway, that's all. I just want to say I am in support of denying the waiver.
Okay, thank you for your comments. Gina, it looks like maybe it's Gina that has her hand up this time.
I'm sorry, I just wanted to apologize to Hubie. It wasn't directed at you. I'm sorry, it's a new process here for DRB, so clearly you're not handing out waivers like candy. You're new, so you can't. That wasn't my reference, so my apology for you taking it that way. Thanks.
And
Thank
just
you.
for the record, that's Lorraine speaking, correct, Lorraine?
Thank you. I'm sorry, we sound alike. Yes, thank you. Sorry.
And your name looks awfully a lot alike.
It does too. Sorry about that, Ian. Thank you for your tolerance.
Yep, thank you. Okay, anybody else in public? Yes, ma'am. Come on up.
Hopefully it's right this time.
Yeah, now you have your chance.
And I'm not going to, okay. Mary Post from 1 Cindy Lane. And I'm not going to be speaking technically, but just my feelings about this whole thing have to do with the second access. We have just been told so many times that nothing else can be built until there's a second access, and then it gets waived. And I'm getting more and more concerned. I remember we at one of the meetings we said, well, we have so many big white pines in the neighborhood that if one goes down, let's say that we had a big storm and a pine went down and an ambulance couldn't get in. And I remember we were kind of laughed at and said, the fire department, they've got chainsaws on those trucks. They'd get that cut up in no time. It's not going to be a bother. Well, it would be a bother if you're having a stroke and you've got that golden hour to get to the hospital. And storms are getting worse. It could be a much more major storm that they couldn't cut down, cut through the trees to get there. They might not have staff to staff the fire trucks. There's all kinds of things that could happen. And I think just to be so blasé about all of this is just, is not thinking ahead. And I think that we need to finally go by the rules in this town and say we need a second access before anything else can be built. And as Betsy and Carolyn made reference to, the infrastructure is already failing. We have a poor water system this was years ago that we were told we didn't have enough water pressure. Asbestos pipes that need to be replaced. One of our streets, every time there's a big rain, the basements fill up in these homes. And they have been trying to work on that, but I think it's still a problem. So we're going to be adding more to that. As Carolyn said, or I think it was Carolyn, we have a little sinkhole right now in the middle of Tanglewood and Cindy Lane, and we're on week 3 now where nothing's been done about it. And I've noticed that about 5 feet, 10 feet, going more towards Sand Hill, there's another, what looks like a sinkhole developing. It's like a round pothole, which is what the other one looks like, but it's got an actual hole in it. And they're not even able to come up and deal with this right now. And yet we want to add more and more. It just doesn't make sense. And the other thing I want to say is I have gone to so many meetings about the town plan. And I've come to the point about why go? I go because I'm a citizen, but it's not listened to. It's like we're just talking to the wind. They don't go by the rules. We weren't supposed to have a building over so tall. And then it happened. We didn't want to. Wait, I'm getting off track, so I'll stay away from that. But there have been so many waivers on different things that it's like, what's the point of even going to the meetings? And I had to kind of chuckle when, like when we had to come in and say everything we say is honest and truth and this and that, and we talk about integrity, and yet when you deal with the town, and I'm not talking about the individual, staff people at all, but it's like, Sharon, your boss, Jerry Furkey, told me 3 times maybe, they will not develop behind you. And then as soon as the popes moved away, the town did not like the popes from what I understand, all of a sudden it opened up where it could be sold and houses could go. And so it's like kind of like a ping pong. And it almost like it gets down to be a personal thing where, well, some people are going to get the waiver, some are not. It's what it seems like, and it may not be. But we've been so frustrated over all these years that we have faithfully gone to planning committee meetings, faithfully gone to other meetings, and it's like nothing matters. It's like it's all been planned before. And so now it's another chance for us to say, please, would you give us that second access? A lot of us are now on gas. I didn't want to get gas because I'm always afraid of a house blowing up or something. But a lot of us are on gas. And what if there were suddenly an emergency where they said everyone's got to evacuate? We would not have a chance to get out if everyone heard that and they're feeding into the same road. You would not. We wouldn't get out. And I remember Dwayne saying tonight that one of the things that this group is to consider is the safety of the citizens. And this has been discussed so many times in front of a planning commission that if we do, I believe anyway, if we have a major storm, and let's just use the stroke example, and somebody has a stroke and ambulance can't get there, you will be sued. Because it's on the record that we have been begging and begging and begging for you to pay attention to the safety of our neighborhood. And it just doesn't happen. And yet I see everybody dotting the I's and dotting your T's and crossing the I's to make sure that everything is totally fine for the developer or for whatever. But for the citizens, maybe next time. So I am upset, I'm frustrated, but I'm sorry about that. But I just hope that sometime people can come away feeling like they're going to be listened to, that we matter. Because that's why you don't get people participating now. However, people are starting to participate. I think people are starting to feel like maybe citizens do have some power. I think there's a turning point. So I'm really looking forward to that. And I thank you for all the work that you do. I know there's a lot of work in this, but it's very frustrating to be on the other side too. And so if we could have meetings where we really feel like we could talk, and like you said tonight, you had a light agenda, but you want to close it off after 15 minutes. So I think we've already gone beyond that for sure. Thank you very much.
I was more in reference to another topic that we've heard a lot of lately.
Okay. But just like, let the people talk. And you did at the school on the other issue, and I thank you for that. So anyway, that's what I have to say.
Thank you for your time.
And we welcome any of you to come to Cindy Lane and to Birchwood, the whole area, and we'll give you tours.
Thank you. Will there be cookies? Okay. Okay, yes, ma'am.
I'm just going to flush out one of the things that I said that I was trying to make it very concise. With the stormwater that we have.
Betsy, can you give your name again?
I'm sorry, Betsy Dunn, 2 Cindy Lane, Essex. The infrastructure is bad, but we have a bad issue with storm runoff. Fern Hollow, which is just before you get to Cindy Lane, it is there are 8 parcels, I believe, out there. It might be 9, but there are quite a number of parcels. But they're of absolutely no use to the people who own them because they're just falling away because of erosion. And one of the things that they came and talked to us about 4 years ago, 4 years ago, I think somewhere around there, where Aaron and Annie came over and we had a conversation with all of us because they wanted to know what could we do about it. And they were talking about putting an island for vegetation and flowers or whatever all the way up the center of Tanglewood. That would help. But that wouldn't help us at all because that actually would make the road smaller and you wouldn't have a second access. And so we've limited them in some of the ways of how to help us prevent our houses being slide down a mudslide like they do in California. So I think this is really important, this whole access because it's a wider street. You know, I was at a meeting and one of the developers, I think he was, I don't think he was a lawyer, he was a developer. He said, well, there are trees coming down in my lot and they're hitting the cars and everything. I couldn't find that in any kind of a report. But in our neighborhood, that could easily happen because we do have a lot of those big pines. They're huge. And we have to find a way. That's the issue. We must find a way to have second access. Thank you.
Yep. See no other hands here in the room. I see one more hand in the room.
Tom Yando. I live at the bottom of 11 Linden Lane. I love to serve my community. Down at the bottom of 11 Linden Lane and in our house, there are 4 of us that are on the fire department. Things that aren't seen in the neighborhood is every time that there's a storm, we go out before we get to the fire department. I own 3 chainsaws. I bring them with me. I cut up branches. I move them to the side. I have a person who lives also within my house that works for Public Works. He's also out all the time. As far as this one access in, again, Tanglewood is the largest road that is in the town of Essex for developments. But as far as I see, when they built the 51st house, a second access should have been put in, but it wasn't. But here we are, 163 houses later. Let's keep going. The other is, at what point, whether it's 50 houses or not, there's other developments that have gone in with single access. Saybrook, Lane Farm, Indian Brook Road, Brigham Hill Lane, Bixby Hill Road past Irish Street, Foster Road, which isn't even as wide as Tanglewood Development, Corporate Drive past Belkate School, Allen Martin Parkway past Hickory Lane that goes into all the townhouses that are all in the back there, Sunset Drive, the Price Chopper Complex. We've had a few accidents at that corner that could limit us to get into the Price Chopper Complex. Morris Drive, Royal Park off Pinecrest, and the newest, Elsa Lane off Pinecrest. At what point, these things are already granted, whether we've got 2 accesses or not, and the fire department is going to get there, whether there's a tree down or a car accident. It's just in our nature. We need houses in Essex. I looked up the other day, the median price for a house in Essex now is $522,500. In Chittenden County, it's $579,000. My 3 kids can't afford that. And my son, who works for Public Works, he and his wife probably make $80,000 to $90,000 a year, and they can't even touch houses in Essex, which forces them out of Essex. I moved into Essex because of the education. The education is still top notch. Why can't we still keep building? Thank you.
Thank you, Tom. Yes, ma'am. Is this new information or is this a rebuttal of previous information?
It's not a rebuttal, it's the type of conversation
Sure.
I'd like to have.
That's fine.
Okay. Mary Post, Cindy Lane, in Essex. And I love all my neighbors, and I know a lot of people I really like on Linden Lane. And I've maybe even talked to you before when I'm walking the dog. But I just wanted to say that all the other places that...
Can you address us, please?
No, all the other places that he mentioned probably don't have a rule from, was it 1995, that there will be a second access. So I just don't know. I mean, that's a bit of a difference. Now, maybe all of them do, all these new places. You will have a second access. That's one thing. And the other thing, it's already gone from my head, that I wanted to make a comment about. Oh, I'm forgetting now. But anyway, I don't think you can totally exactly, you know, say just because the other ones coming in don't have one, that it's not the same for us. And it's also what the citizens want. You have a lot of citizens that have been requesting this for a long time. And so just stick to what we want for our, you know, that what we want to have for our neighborhood. And then we will listen to other neighbors. Okay, thank you.
I see that we have a hand online. Gina Halpin Barrett. Or is
Hi,
that
it's
Lorraine?
No, it's really me.
Okay.
So when I'm looking at the map for the ones that were just mentioned,
Can you
I
put your
see-
hand down? And Gina, did you swear in before as well?
I did.
Okay.
Sorry, I can't see to put my hand down. There it goes. I see that Almar Parkway, which I live on Sand Hill Road, does have a second access. You can cut through on Hickory Lane out to Sage Circle, up Butternut, and then up onto Sand Hill. It has 2 exits. So I'm not sure all those references were
I think you're talking about the
accurate.
end for
That's
the
all.
condos.
Thank you.
The far end of that road it branches left and right, and there's a series of condos and townhouses, and those don't have second exits. Both
They
of those
don't right
clusters.
there, but they do. That's not 163 homes, and it does have a second access off Sage Circle. I mean, right at the end it doesn't, but
That's
our
I think
2
that's
exits off Allen Martin Parkway itself.
yeah, Mr. Yando. Were you referring to those 2 clusters at the far end of that?
Correct. After Hickory Lane, correct. There's
Okay.
only one entrance.
It's not 160 homes.
Doesn't matter.
I mean,
It's over
there's a second access off Allen
No,
Martin Parkway.
I think he's in the back of the room, not near the mic. I think if I'm correct in understanding your point, is each of those areas have greater than 50 units, and they don't have second access points in those 2 clusters of housing.
Correct.
Okay. Okay, so that's just to clarify that point.
Thank you. Last comment, please. Yep.
Just for the purpose of providing information.
Sure.
Bruce Post, 1 Cindy Lane.
Thank you.
Didn't the planning commission or the select board really get into trouble in Lang Farm because they wanted to put a road through that would qualify as a second access? And I remember they got channel 3 here, they had signs and picketing, and you do have an emergency connection now, don't you, between Lang Farm and Pinewood? There are chains or something, but you could get out that way or in. I don't know. I don't go in Lang Farm.
That was a very lengthy process. You are correct, and there was a lot of back and forth, and the community did not want a full second exit. So now there is a trail.
Okay, there's something there. So
I don't know that it's vehicle ready.
Yeah, I don't know what it is either. So that's just what I wanted to ask.
I was going to mention that too. Thanks.
I don't want to wear
Thank
out
you.
my welcome.
No,
Thank
I appreciate that. Thank you. Yeah.
I'd say that was a very much a NIMBY, not in my backyard. I don't want traffic going through my Pinewood Manor. I don't want traffic going through my Lang Farm. It was kind of nasty. And
Yes.
just as a comment, okay, and is that you don't get me wrong here. You might want to be careful about what you're asking for. You get a second access, your traffic may change, okay? But anyway, I'm not suggesting that would be a problem, but that's another thing to think about, okay?
Additional flow.
Yeah.
Okay. So we have no more hands online. We have no more hands in the room. I think at this point, we've had a fair amount of input. Further discussion here among the board. I think
I'd offer a motion to close the public hearing if you'd accept it.
I would accept that motion. Yes, thank you.
So moved.
So we have a first movement by Dusty to close the public hearing. Do we have a second?
I'll second.
Okay, Trevor seconds. Any further discussion here amongst the board? All those in favor say aye. Aye. Opposed? Motion carries 6-0. So the public portion of this hearing is now closed. It's now time for deliberations amongst the board. So, Hubie, you never one to lack.
Yeah, well, yeah, I have quite a few thoughts about this. First of all, the whole business about trees falling across the road and so on. I've been involved in when there's been heavy storms, and there are so many trees that it doesn't matter whether you've got a second access or not. You're going to have portions of an area that's going to have difficulty getting access. So to suggest that one tree or a couple trees across the road is going to be a calamity, you can draw lots of different scenarios about what could happen. I'm an engineering type. I would wonder if there hasn't been some study or analysis to say what are the possibilities of limiting access for whatever reason. How many trees are there that could fall? What's the storm activity that could cause a problem? What is the probability of a car catching on fire and blocking the access? Okay, the comments that we're receiving on access are subjective, okay, at best. There's not hard evidence, all right? Now, we could talk about that forever, but I don't think that is the reason for the 50 house limit. To me, that seems arbitrary. It's interesting where that came from. Why isn't it 25? Why isn't it 10? I don't know why it's 50, okay? So here's where I stand on this. The regulation says 50. So I'm going with 50. And what Bruce Post said is something I've been thinking about, and I've commented about this to many folks. Essentially, every one of those lots in there has an opportunity for an accessory dwelling unit. You could start having mini houses show up on the backs of some of these lots that are bigger. There certainly is an opportunity to increase the population in that area. You got issues for sure, sewer capacity, water capacity, etc. But Bruce is correct. The state laws now are making this a lot more lax as far as being able to create more living units. So I tend to agree that this is not the end. There's possibilities for more living units in this area. So that being said, doesn't matter, okay? The regulation says 50. I'm going with 50. I would deny this waiver.
Okay, thank you, Hubie. Dusty?
I'm going to go back to what I brought up earlier. To begin with, I would insert the applicant's request for a waiver, their page 2 at line 152, and also insert the last paragraph on their third page, which says specific to the simple parceling, continues down through without adversely affecting the intent or purpose of the town plan or the zoning regulations. That would very specifically cover why they feel a waiver is appropriate for this. And I believe every applicant has the right to request a waiver unless it is so there was a prohibitive waivers are specifically prohibited in the regulation. So they've requested a waiver. I understand that the build out can continue. In fact, the accessory apartments could happen today. They don't even have to be extra buildings. They could have the mother-in-law apartments could go in today. As you mentioned, Hubie, that could happen, boom, right now. And you could double the occupancy of that whole entire development. As Bruce mentioned, this is sort of a full circle, and we were back at the beginning of this, and I do recall the initial request for a waiver. You know, the development at that time, I believe, was greater than 130 units already, so it already exceeded the 50 unit limit, and that was 15 years ago, something like that, more, 20?
It was around 2005, 2006 it started, I think.
Okay, so 20 years ago, and it already exceeded the 50 unit limit. And the decision that which was upheld in court review was that it wasn't going to adversely affect the safety of the neighbor of the community. So I think that to me lends support for this waiver. I do feel that this needs to go to the planning commission and this needs to be addressed promptly before any additional development can be put through, because do we need to either remove the 50 unit limit? Do we need to put some teeth into it so there's some engineering as to why, and so forth? And given what's coming at us, the 50 unit limit may be hit with an existing 5 unit subdivision as soon as they start putting the state allowed expansions on. So a short version is strictly based on the request of the applicant. I think that they have outlined the reasons why they feel a waiver is appropriate, not disrespecting the neighbors or the neighborhood in any way, shape, or form. I don't think that this application should be denied at this stage. I think the future is going to be challenging. And I think this should be an #1 topic for the Development Review Board to send to the Planning Commission to put on a fast track. Especially given that waivers in general have been brought up multiple times in recent history. That's it.
Thank you.
Well, I guess I'm just a little confused in the sense that, so at some point someone built a large development, and for whatever reason, second access wasn't provided. So then I don't understand how law works that, so an individual who owns property in the development then could be forced to provide the second access, but they're just an individual. They weren't the people who went and got the waivers and things for that were allowed to happen. And I don't know. I guess I agree with Dusty that probably a waiver is okay.
Okay. Good?
Yeah, I'm good.
All right. Nick?
I tend to agree with Dusty's comments and Trevor's comments. It's shocking that the development has been allowed to grow as exponentially as it had with this 50 unit limitation that's essentially ignored whenever the development is proposed. And so when is it appropriate to say no? When is it appropriate to add on another 50 in any development? And so using that logic, I suppose one more doesn't compromise the safety of the neighborhood or the community in an alarming rate. However, there's potential for more growth. I'm still pondering. That's all.
Thank you. Before I get to Stephanie, I just have a quick question, just for the general public, and not in the least of which my own knowledge. If somebody decides that they wanted to add additional housing on their existing lots and have the acre or so to do so, what's the process if they wanted to do that? Do they just up and build it, or do they still need to come to the town?
Well, they'll always need a building permit at the very least.
Mm-hmm.
So, right now, our regulations allow a second house to go on a property, not just an accessory dwelling unit. So it could be a bigger house or not.
But they would still have to meet
They'd have to meet the setback requirements.
and septic and
septic if it is private septic,
Right.
otherwise, and pay the fees if it's town water, town sewer.
right. They wouldn't necessarily have to come before DRB, but they'd still have to go through.
They would not
Steps.
have to come before the DRB if their lot was big enough and they met their setbacks and they
Right.
weren't looking for a variance of setbacks or a waiver or anything.
So would there be flags?
Now, we're talking about outside of Pinewood where this, has the waiver
Okay.
requirement.
Right. And within Pinewood?
Why are we
I'm
talking
sorry, I
Pinewood?
said Pinewood, I missed.
Tanglewood.
Tanglewood, I mean Tanglewood. So,
Tanglewood.
right. So, additional houses that would go on, that, again, could be 5-unit dwelling if they wanted to.
Act
Would
46
still need,
Yeah.
would still need to go through an approval process, and it would still need.
Either administratively through the zoning administrator or dependent on the circumstances through the DRB.
And would that trigger concerns for, as that happened, would that trigger concerns for the secondary access? Would it trigger concerns for upgrades of the septic that?
Well, right, the 50, it would definitely come before the DRB if it's a development that has 50 already,
Right.
as long as we have that. But if,
Right, the limit at the moment is 50. We're talking about doing a waiver for one more house. Any other future houses would, if somebody were, again, to put in another 3 units on their property and had the capacity to do so on their property, it would still come before it would still have to ask for another waiver.
correct. And in speaking specifically to Pinewood, sorry, I don't know why. I said
Tanglewood,
Pinewood,
Tanglewood, yeah.
Birchwood. Let's see. Well, anyhow, that doesn't matter. But yes, if we're talking Tanglewood, they're coming right, if we're talking Birchwood, they're coming right back here. But anybody anywhere else, no, if they meet the dimensional requirements and they only have a single family home on it, they can come and pull a building permit
Right.
and build their second house or build an accessory dwelling. The difference for the audience is accessory dwelling is the landowner needs to live on the premises, either in the house or in the dwelling unit. So they can't buy a property, create an accessory unit, and rent both out.
Right.
But if they built a second house, they could rent both.
They could build a tiny house and rent out the master house.
Mm-hmm.
Yeah.
So, years ago in talking with Randy Vance, the former assessor, he cautioned me when I was talking to people to say, people think they're going to put a second house on their property and save money for their kids' education, but their taxes are pretty much going to be very similar to what they're already paying, just double it.
Right.
So they might not be making a big profit if they're renting.
I guess the point of my question really is that when we're looking at particularly this application and a single more
Yeah.
property and our goal to add to the deed that it has to remain a single family property on both parcels, and understanding the concerns of the neighbors where infrastructure is failing a little bit and the secondary access piece, should there all of a sudden start being a spring up of additional houses that would go up within that neighborhood, which currently requires a waiver for anything because there are over 50 houses in there, it would still come back to us. And
Just for the 50, yes.
just
Because of the 50.
because of the 50, right, would still come back before us. And so there's an opportunity for us to, as let's say a developer buys up a couple of the houses and wants to build additional houses on those lots. That's an opportunity for us to force the developer to create that secondary road.
Right. And Dusty pointed out, this is a good discussion for the Planning Commission
I agree.
to have because
Yep.
the state is forcing communities' hands by, their target of they want
I
more
agree.
housing, they're desperate for more housing, and maybe the 50 house rule is moot.
Right.
Discussion for the Planning Commission to bat around.
Right.
Just a quick follow up on that. When do we know when, and maybe Mr. Post knows this as well, when the 50 unit restriction became part of the regulations?
Subdivision regulations requiring second access for developments over 50 dwellings came into effect September 1996.
Okay, and Tanglewood existed long before that regulation went into place and exceeded the 50 units at the point that it went in. So I think that my recollection is that was also a factor in the evaluation of the waiver. So, okay, thank you.
Thank you. Thank you. I didn't have anything other than I just wanted to make sure that I understood the process for if additional housing was to go in or try to go in. So, Stephanie, since I took your time, go ahead.
I hear what all of my fellow board people are saying. I am kind of in the camp of Hubie. I think the waiver makes a perfect argument for why they should get one. But the regulations say 50. We're already well over that. We're at, 163. At what point does it stop? At what point is it too much? And and I can see where the citizens are saying one more. And yeah, in my mind, I'm like, it's just one more. But at what point does it stop? And at what was the amount when it went to environmental court and they ruled it wouldn't be an adverse impact? Have we already added more to it since that time? So now have we reached a level where it would have an impact? So I'm struggling with asking for one more when we're already well over what the regulation says. And I agree, it needs to go to the planning commission because I think 50 is an arbitrary number at this point. And it's also hard when you have your emergency people saying, I don't have a problem with it. So all the questions about that to me are moot because the fire chief's saying, I don't have a problem with it. It's not going to impact us. But I do have, we're well over 50. We're well over 100. And when is enough?
So I would just add too that aside from the last subdivision and the fact that they're willing to put conditions on their deeds for no more, an accessory dwelling unit can be as large as 900 square feet. So these other homes outside of the Owen Jenkins, could have a lot more units.
Yeah, which we have no say over.
Right. So I just point that out.
Yep. Okay.
Yeah, I'd like to add to what Stephanie said that I don't disagree that the police department and fire department, they don't have a problem, and I can understand that, okay? But the fact is, the regulation says 50, okay? And so if we wrote that down as the rule, and that's what we should go by. So whether we can agree or disagree, or whether there's a safety concern, or whether we could get in there on an emergency or whatever, I think that's a lot of distraction, all right? It's 50. So that's why I would not be in favor of granting this waiver.
Okay, well, any other comments? Nick, you were still undecided at the time, so we're not actually doing a vote here. It's a conversation.
It's just a conversation.
Just a conversation.
Point. I'm curious. I'm not asking or even implying or suggesting the applicant may consider some of the topics that we're talking about, an accessory dwelling unit, instead of subdividing the property. And so if that might be of interest to the applicant.
Nick, I just remind you that the bylaws for that particular subdivision Owen Jenkins created does not allow for an accessory dwelling.
Oh.
The bylaws don't allow it until somebody challenges it.
Right.
Yeah.
Which they could probably with the new Act 181 and Act 47, they could probably say the state is going to trump it. Okay. But they haven't yet.
It would have to be a battle.
Yeah.
So, yeah.
Everybody loves a good battle.
Well, we're getting used to them, that's for sure.
Right.
Welcome to the neighborhood.
Okay.
Can I offer just another? hear what Hubie's saying. I don't disagree with it, but we also have the ability to request a waiver. So the DRB's role is not necessarily to solve the future projections as much as it is, that's more the purview of the planning commission to set the regulations in place and put the language in that maybe narrows down the ability to use a waiver. But I think the applicant provided significant documentation in support of the waiver in this instance, not necessarily what the future is going to provide. I think we're going to have some bigger challenges than this one subdivision application, which, as Sharon pointed out at the beginning, this originally came in as a consent item, which simple parcelings generally are considered consent agenda items. And this one, due to the nature of the need for the waiver to make this fit, or not, as opinions may, not agree with, it needed to come in for that bigger evaluation. But it still is, from a development review board, it is an application in front of us. They've requested a waiver to the regulation that says 50 unit limit, which is allowed. And I think we evaluate the waiver and decide whether or not we agree with it. And I think, nobody has to agree, but I think that's where we're at.
Oh, I don't disagree, Dusty. I think, though, that we're at an inflection point with the number of homes already there. I don't disagree. I think the waiver was well written and the points are well, but at what point is it we've hit the cap on allowing waivers based on these things because we've gone well over the amount of homes in this development? Yeah. That's where I struggle with it. I don't disagree. I think the waiver was well written. I think the points are well written out. It's at what point I can look at granting a waiver for over the 50, but we're at 163 homes now. At what point is it past that? No more. That's where I'm at, and I'm not thinking about the future.
Yep.
I'm thinking about currently, right now, that development, the impact, and that's where I'm having the struggle with that approval. Is that I think we've hit that max at this point.
Well, if we look back, we actually hit that point with the very first request, which
right.
the regulation went in after the development was created, after the development was populated out to 120, 130 units, something along those lines. So the evaluation was done, was the safety an issue at that point in time, and the decision was the waiver was supported because of the impact was minimal. Every time that waivers come in, it's the same evaluation has been done. And we're statistically not, I don't know statistics, I'm not good with numbers, but it just feels like we're so far beyond the 50 that the 50 really is not relevant anymore. Is this having a negative impact? Is this request that's in front of us having a negative impact to the safety in the existing time frame? So is it a waiver, yes or no? I think the long-term thing, the what's enough and what's appropriate, that's a planning commission that needs to be codified into the rules and regulations.
Yeah, I have a list of those things.
We're finding new ones every week.
We need to send them a formal request.
Yeah, we do.
Actually, we should.
We should.
So I will just remind you that we can't continue this because the missing DRB member is recused.
Yeah.
Mm-hmm.
Okay.
Yep.
Just wanted to make sure.
Yeah. No, I think we've come to a point where we've had, I think, a fair amount of discussion, and perhaps ought to bring this to vote at this point. If I had a motion, I probably could do that.
I can offer a motion and let anybody who wants to take the journey with me add comments to it. I don't recall the edits that you maybe offered in the beginning, but I would move that we approve the 2-lot simple parcel subdivision as presented this evening, with the edits that Sharon offered at the beginning, which I don't recall what they were. But I would also offer, as I mentioned, starting at line 52, I would like to insert the applicant's page 2 of their submission, items, the first sentence, and then items A through J, and then the paragraph on page 3 that starts with specific to this proposed simple subdivision and ending with town plan or the zoning regulations. And then under planning commission, development review board findings, I would say that the development review board accepts the waiver request as presented and as supported by town staff and town departments, and acknowledge that that acceptance is not unanimous.
Point of clarification, if I may. The items that you had mentioned Sharon made, are you talking about the dates of received emails, or are you talking about the conditions that were strict through that aren't necessarily need to be removed?
You offered some edits at the beginning.
Right.
That's
So
what I'm asking. What
I think
you're-
it's more about
what you're
the
talking
deed.
about.
finding 12 and 13, I amended because I
Okay.
never updated that.
Got it.
And then the ones that were struck, the applicant requested 3 more, but I had requested to not strike those just because I think it's good for a contractor when the construction starts.
They didn't offer they didn't put any additional burden out there because the applicant indicated they'd already met them, so they were not invalid. They were just already completed.
Right.
And the other condition was, as you'd stated, the language to
Correct.
to lock in any provincial
The deed.
the deed
language.
language.
Right.
Right.
Yep.
Which, if you don't mind.
Oh, which is, sorry, let me go back to my cheat notes. Okay, let's see. Have agreed to a condition, the applicant shall submit draft deeds for the proposed lot and amended deed for the existing lot for review and approval by the town attorney at the applicant's expense. Proposed deed language shall include the following language. Each lot is approved for a single-family structure. No further subdivision or dwelling units, including accessory dwellings, shall occur on either parcel.
So they will remain single-family homes
Just
per the deed.
single-family.
Thank you for that motion. We have a motion made by Dusty. Do we have a second?
I'll second.
Trevor seconds. Further discussion?
Yeah, I would add that, I think I've made it clear that I will not vote in favor of this motion. But should it pass, I would suggest that line 282, finding number 11, that at the end of that should be added, or fees in place at the time of the application shall be paid prior to the issuance of a zoning permit. That is typical language that was just
Yeah,
left off
thank
there.
you, QB, I missed that.
And also line 307,
I'm sorry, did you say finding 11?
excuse me, condition 11, I'm
Condition
sorry.
11.
Condition 11
Yeah.
on line 282.
Page 7.
You know, it's a standard language that,
Yep.
you know. And then also on condition number 19, I don't think we need that statement there.
Yep.
All construction shall remain within the, oh my God, how are they gonna build their driveway and put their utility in? I think that's just a cut and paste thing that just needs to be eliminated.
Yep, thank you.
So you're offering both of those as friendly amendments, and I would accept them as friendly amendments. Trevor?
Yes, I'll second that.
Further discussion here?
So one thing I do want to say, the reason and I'm going back to the discussion we had earlier, the reason I wanted to have the details of the request embedded in the application is because, as we heard through a number of folks, why are they getting waivers and so forth? And I know that the exhibits are attached and exhibits can be found. But if you're picking up one document and you're looking at it and you don't see a reason for that waiver right in front of you as you're reading through it, I think that's a miss. So that's why I put it into this. We can knock it around or take it out in the future or discuss it again at another point in time, but that's it.
Okay, thank you. Further discussion? Okay, we'll take a vote. All those in favor, say aye.
Aye.
Aye. Those opposed?
No.
No.
Motion carries 4-2, and we'll note that Hubie and Stephanie voted in the nay.
Don't take offense, but I just add sins of our fathers.
Motion passes. And I would like to take a moment and let the public understand, both online and here in the room, this is a matter that we take very, very seriously. This was not a whimsical matter in any way, shape, or form. So understand and we appreciate the public coming and having your voices heard in regards to what your wishes are within the neighborhoods. I would hope that you would continue to do that again and stay involved. I think this DRB is very, very much being thoughtful about what they're doing with each step. I hope that that was something that you saw here this evening. So, thank you. So the motion has passed, and now we are on to something else. Approval of the minutes of the meeting.
I'll make a motion to approve the minutes of the meeting of May 1st as written.
As written. Thank you.
Second.
It's been, motion was made by Hubie, seconded by Stephanie. Do we have any further discussion about the minutes? Hearing none, all those in favor of approving the minutes of May 1, say aye.
Aye.
Those opposed? Motion carries 6-0. Other business?
None from me.
I do think at some point we should have a meeting that's more of a working kind of a meeting where we do look at some of these things that keep coming up and do a formal request to the planning commission. You know, steep slopes is one, this 50 house thing's one, you know, and really ask the planning commission to look at these regulations, because the areas where we're seeing waivers come in a lot, I think maybe the regulation is old, maybe it's outdated, and it needs to be
tightened up.
It needs to be tightened up, so that's not an option. And I think it would help with that transparency for us and for the public to understand. And I think it's also important that we also look at how the town plan gets enacted into site plan review and everything, because not every application is going to meet everything in the town plan.
Right.
It's going to, and what is the expectation? How many of those does it hit versus it doesn't hit any at all? So I think to think that any development is going to hit multiple things throughout the town plan is unrealistic. So like,
And the town plan is a guiding document.
right, what is the threshold that the select board or the planning commission expects a project is going to hit? Is it going to hit 3 things, 2 things, 5 things?
Right.
Like, and what are those things? So
Yep.
I just wanted to put that out. I think
It might also be some guidance from select board as well.
Yeah.
Would be helpful.
would be helpful.
Yeah, no, that's a good point, because you're right. You can look at the town plan and you can say, yeah, we're hitting those, yeah, but wait, we're not hitting that one, but what does it matter, you know? Let's see,
Right.
we scored 80, so let's go ahead, you know? So what's important, you know?
Right. How many
Yeah.
do
Well,
they
right.
want to see, you know, hit
Right.
versus any, or maybe it's just one. I don't know. But I think we need that feedback and that guidance.
And I think as we, I don't mean to cut you off, Hubie, I'm just saying, I think as the DRB is moving forward and we're starting to find our footing a little bit, it will be helpful for us to have a better direction from both PC as well as the select board, really, about how much weight do we need to put into those areas.
Right. And how much weight does Act 47?
Right,
Yeah.
exactly.
Oh, yeah.
I think right, and planning that's more. Again, I'm cutting you off.
Yeah. Oh no.
The planning commission really needs to be concerned about Act 47 and how that works, and because it's not necessarily in our regulations, our guidance at the moment.
Right.
But it's and thinking forward about how Act 47 is going to affect some of these developments isn't necessarily what we need to be doing.
Right.
But I can tell you that they are working on steep slopes. So.
Thank you.
I think one of the reasons, and I'm not a political science person, but the reason that there is a DRB is because there are exceptions. Okay, you can't write rules that cover every last thing.
Right.
So you have to have a DRB that can rule on these exceptions. And one of the keys that I've always kind of locked on is the two words: does this impact this situation? That's not the simple answer. Does it adversely impact? Because most, it's the old butterfly effect. All right. When the butterfly flaps its wings, you feel it in China, whatever. So essentially everything that you do affects other things. Does it adversely affect? And that's where we have to understand and try to put our handle on that. And that's not always easy. So.
Good night.
So I do have one other thing for other business.
Yes.
And I'm glad that tonight that you read the oath as it's written in our operating procedures.
Yep, that's where I got it.
And I believe that I think this mass, applying the oath to everybody and then online, and it makes us look a little stupid, I think, when we say, wait, did you take the, wait, there's 50, particularly these big meetings when you got a whole screen full of people. Well, who took the, well, I didn't, they raised their hand, they don't even know how, well, they're not sure. I don't, how do I raise my hand? Wait, my video's not on. So that, to me, to ask somebody, well, did you take the oath? That suggests that we're not paying attention, or that so my thought is that anytime anybody's going to testify, that they be given the oath at that time. It's going to take about 10 seconds to read that, and it will take them about 2 seconds to say, I do, and we can go forward. And that will do a couple things. I think it will provide some more credibility to this process, to say this is a quasi-judicial process. This is not a gang show, all right? So we want to have you understand you're giving testimony to the penalty of perjury, okay?
Hubie, you're talking about online, correct?
I'm talking about in person or online. Either way. Somebody wants to, so raise your hand, okay? And by the way, turn on your video if you have it. That's not a hard thing to do. And so, and not that I think there's a reason for doing this, but it may cut down on some folks that want to testify. Wait a minute. Did you take the oath? Yeah, I took the oath last night at the AA meeting.
If it helps at all, Hubie, I actually have the Zoom on and am watching hands specifically.
Yeah.
So when I offered the oath earlier, I know which ones gave the oath and didn't. I call out people who don't. But I understand what you're saying, and I think that's definitely something that we can consider going forward.
And particularly these large meetings, you've got a whole room full of people, and you got a whole bunch of people online.
Yep.
Who's on first here? So a suggestion.
Yep.
And whether that be incorporated into the operating procedures more explicitly or not, because our operating procedures don't say, it just says the oath shall be administered. It doesn't say what the. So it's something to think about for another time. So.
Yeah.
I'll offer a response to that. I appreciate the suggestion, and if we were to move forward with that, we might want to consider starting our meetings at 6 o'clock instead of 6:30.
I second that.
We'll need more time.
Yeah.
And historical meetings in the last couple months, we need more time.
I would venture to say that in particular the last meeting that we had with a number of people who spoke, repeatedly giving that oath would have cut out some of the folks. We would have run out of time much earlier.
Yeah. And that's not the purpose of it. But I think that it brings more credence to the process.
Yep, that's true. I mean, in a court of law, you have to swear in every witness. So, yep.
Couldn't you do it just with the people online? Because
that is a possibility. We're just having a conversation at this point about what we can do. So
But when you got this room, how many people at the education? Were there 75 people there or whatever?
Yeah.
You know, wait a minute, that guy in the back, did he raise? Wait, she didn't, you know. So.
Realize too that the large meetings are the exception.
Correct.
So that may be that it's for something that is anticipated like that, an alternate process is put into place to make it more effective.
Correct.
And it probably would actually save time by doing it when you walk up to the podium. That's the point that you do. You
Maybe
sort
we
of-
put the oath right on the podium and say that before they can even speak, they have to provide
Just
the
like
oath.
that.
Yep.
Yeah.
Ian, can I just, I'm not speaking as a member of
Chuck's
the
leaving.
planning- Huh?
Chuck's leaving. Didn't say a word.
I'm not speaking as a member of the planning commission, I'm just speaking as a member of the community. I think that the state is being extremely short-sighted in its proposal of adding units. Especially if they're adding units to houses in developments like Tanglewood and Perry Drive and the smaller houses. Because those are the houses that are at least affordable or reachable for a number of people. And you start adding more to that, you're just increasing the price of the houses that people are likely to start in anyway. So, you know, I don't think the state has thought this through in terms of, you know, I don't know whether you set a limit in terms of the price of the house and, you know, make it a recommendation for houses above a certain price. You know, I mean, there are ways to think about how to make it effective without undermining the very thing that you're trying to accomplish, and that's making houses more affordable for people.
Yep.
Thank you.
Thanks. Anything else for other business?
No, not from.
I would guess I would take a motion for adjournment.
I motion we adjourn.
I have a motion from Stephanie and seconded from Nick. Do we have any further discussion about adjourning?
Don't think we can.
I don't think so either. All those in favor of adjourning, say aye.
Aye.
Opposed? Motion carries 6-0.
8:21.